self-defense apply. You can't be responsible for creating the situation. Okay, so if two guys are getting into an argument in a bar, that person may not be able to rely on self-defense because he may have had a responsibility in creating the situation. You can only respond with a requisite level of force that's necessary to repel the attack. So if someone is coming at you with fists, it's not necessarily appropriate to respond with a gun.
I see.
You can only use deadly force if you are in fear of, if you have a bona fide fear of great bodily harm or death. So you can't use deadly force to protect yourself from a fat lip or a black eye. And when you're on the street, when you're not in your home or your vehicle, you also have a duty to retreat before you can use force in response to attack.
What does that mean, Bob?
You got to run away before you fight back.
But when we get back to Castle Doctrine, and maybe even the law before the Castle Doctrine as far as inside your house, do you have a duty to, did we ever have a duty to, you did not?
Never had a duty to retreat from your own home. And you know, the Castle Doctrine gets its name from the concept of a person's home is his or her castle.
His castle, right.
Okay? And so you never had a duty to retreat from your own home before you responding with any kind of force. You did have the obligation to have that bona fide fear of great bodily injury or death, though, before responding with deadly force.
Where the gray area is going to come in, and maybe the Castle Doctrine will help here, your home is still a form of property, and you have property in the home. So if you were unfortunate enough to have your house burglarized, if you will, and walked in on the burglar, well, it's a scenario that could happen. Now, we would hope the guy would get scared and run away or whatever, but under the Castle Doctrine, under the new law, what do you think?
Fire away, John.
Really?
Yes, under the Castle Doctrine, if that person is unlawfully in your home, it's presumed that you were justified in using deadly force to respond to that. Now, frankly, that does create some scary situations because you're not supposed to use deadly force just to defend your property. I myself have handled a handful of cases that were burglary cases that resulted in a person who was intoxicated, highly intoxicated, coming home to the wrong house. And I know it sounds funny, but it happens probably 4 or 5 times a year in Medina County.
Yeah.
And a person comes to the wrong house, staggers in, doesn't know they're in the wrong place, and goes to sleep on the couch. In the morning, someone walks downstairs and they find a strange person sleeping on their couch. Now, that's a burglary in practically every situation. But it's a situation where nobody's truly in danger.
Yeah.
The person obviously doesn't intend any harm to those homeowners. It's a mistake. But he's unlawfully in somebody else's house, and if that person comes downstairs and starts shooting, they're going to have a presumption, and a jury would be told that they are to presume that that person was acting in self-defense. So one of the major criticisms of the new law is that it encourages people to shoot first and ask questions later.
I see. Well, laws don't normally move through the legislature, Bob, unless they're lobbied or there's a body of people who support it. And I'm sure for every person we can find that would support the Castle Doctrine, and albeit our legislators voted the way they did, appears to still be a minority rule when you look at all the states. If you said about 20, but it's not a huge minority. I mean, it's turning up. Who are the folks that came out for this? What bodies of people?
The main lobby in support of passing this series of laws were affiliated with the gun lobby, the NRA. There were various special interest groups that were created to support and pass Ohio's concealed carry legislation.
Sure.
It was those folks that after they got their concealed carry law passed, then turned their attention to this doctrine. It kind of dovetailed with the liberalization of the rules for carrying a vehicle in a weapon in a vehicle, because folks with concealed carry permits were still not permitted to carry the concealed weapon in their vehicle, and they didn't like that.
I see.
So at the same time these changes in self-defense were passed, also there were some changes in the rules for carrying a gun in a vehicle. So it was essentially the folks that were in support of the concealed carry law that were the driving force on trying to get the legislature to move on this.
So their argument is just simply a more liberalization of the Second Amendment?
I suppose that's where they get their motivation, but it's it's a concern from their point.